Hi everyone, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we are going to do a last week tonight where we look over the last week's comments to our YouTube channel and we answer your questions and your comments. It's all about you, the viewer, on this episode. So let's get into it. The most recent comment is just 3 hours ago, and it's in response to our video about shoulder injury lawsuits. And the question is, can you sue a company twice? So that's interesting. Now, you can't sue a company twice for the same thing. For example, if I get hit by a FedEx truck, right, and I sue FedEx and I settle the case for $100,000, I can't a month later say, you know what, that wasn't enough, I'm going to sue them again, I want another $100,000. It doesn't work like that, right? When you sign the release, you're releasing them for the rest of eternity, basically, for the rest of everyone's lives. So you can't sue them for that incident. But if the same company, let's say FedEx, does something else, right? Let's say another truck hits you in another incident. Well, of course, you could sue for that because that's a separate incident. So that's usually how that works. 650 Tony says, maybe you should have told this to my POS lawyer. He lost a motion for summary judgment to dismiss because he didn't fight. Now I have to go through this BS and try to appeal it on my own. Don't do business with, and he gives a name of a lawyer out in California. And he's responding to my video, how to build a strong personal injury case. Yeah, I'm sorry to hear that. I'm sorry to hear that, it didn't go well for you and that you have this bad experience, but we'll try to help. Like if anyone needs help, just text me 347-566-9595. I know good lawyers in pretty much all over California, Texas, Florida, the Midwest, East Coast, So that's one of the services that we could help you with, right? If you reach out to us, we can give you a good lawyer who has a proven track record in court, who has verdicts and settlements, and who's not going to lose a motion for summary judgment. Or, sometimes everyone loses, right? Because it's just not legally a case, but you don't want to lose because the lawyer is bad. You want to lose because, you should lose. But anyway, yeah, I'm happy to help. And then Lisa says, would love to hear workman's comp cases, but this was helpful. In response to our video, real shoulder injury verdicts, 5K to 4.9 million explained, part 1. And so, yeah, absolutely. Just let us know what type of work, because workers' comp basically means that the injury happened at work. Now, if you're talking about straight workers' comp cases, you're not going to have verdicts, right? Because that's more of a administrative system. So what they do is they pay you your lost wages and they pay you for your medical bills. They pay your doctors for your medical bills. So you get your medical care paid and your lost wages reimbursed. You could also do what's known as a Section 32 settlement here in New York, where you get a lump sum. So instead of getting the smaller payments every 2 weeks, you get one big sum, but then the carrier gets a credit. And so then you stop getting the small payments. But you're not going to see cases like there's no jury trials for workers' comp unless there's what's known as a third-party lawsuit. So for example, if someone falls at a work site, they have workers' comp because they were working, but the lawsuit's going to be against the general contractor and the owner under the labor law. That's going to be the third-party personal injury case. That's like the big case, right? That could be like 5 million, 10 million, whatever. And the workers' comp is just like an insurance to pay them for their lost wages and their medical bills. But yeah, I could do some work injury cases if that's what you'd like. Here's Chazak says, how does someone that has a question contact you directly? Yeah, absolutely. Just text me, 347-566-9595. The only thing I ask is when you text me, just tell me your name, brief facts, or just 1 or 2 sentences so I could almost like picture or see it in my mind of what happened. Tell me your injuries, tell me the date of incident, your city, and that's about it, really. And then, just a little paragraph. And then once we have that information, we could then schedule a call. And then on the call, we can get into the details and get a little bit more information from you. And I can give you input as well. And then we could do a deeper dive. Like some people want to know, hey, I have a lawyer. What's my lawyer's record? Do they win cases? Do they go to court? So I could search some of the databases like Westlaw, Lexis, verdict search, and I could let you know. Some people might want to know, hey, is this a good case on liability? Is this a good case on damages? What would you do to build up the damages? Because, my lawyer's saying it's worth 100,000, but hey, with these damages, I think it should be worth $1 million. I've seen you talk about cases where this kind of injury gets $1 million. How do I make it the $1 million case, right? So I could give you any kind of advice and we could just chat. So I'm happy to do that. And then Roger says, in his opinion, lawyers are the exact same as insurance companies. Don't let them fool you. I don't think a single case is ever about, quote, fair value, unquote. It's either about how much we save for insurance or how much can I make for the lawyer, all while the injured party is stuck in the middle. Yeah, I mean, I guess it depends on the lawyer. I do know some lawyers that are real passionate and they just care about helping people and that they don't care about their own bottom line. But you're right. I mean, there are some lawyers that they just care about making money and how much can I make. But that's unfortunate, right? Because those lawyers, if they only care about making money and if they're pushing, let's say, a fraudulent case in order to make money for themselves, or so let's say they take 100 fraudulent cases in order to make money for themselves, right? To be rich, get a boat, get a house, whatever. Well, guess what happens? Now, the legitimate lawyers who have the legitimate clients get screwed over because they come into court and then they have that tort reform mentality because of the bad lawyers, right? So, yeah, I guess anyone could be potentially, immoral, or but hopefully we see more of the good lawyers, the strong lawyers, the real passionate lawyers who care about their clients, who do a good job, and who get justice. And then Vic Trees asks, do jurors ever have sympathy for corporations like FedEx, DHL, or UPS? And he is responding to my video about defense's sympathy trick could cost you millions, voir dire, and sympathy. So I would say, usually not. Most jurors are not going to have sympathy for corporations like, big companies like FedEx or whoever, McDonald's, or, but what the defense usually does is, if you're not suing a big corporation, if you're just suing an individual, like a little old lady, what they're going to say is they're going to make it seem during the trial like the little old lady that you're suing, who has, let's say, State Farm, Allstate, whoever she has, or Geico, they're going to make it seem like you're suing her, and then she's going to have to pay you millions if you say that your case is worth millions, and how is she going to get the money, right? So that's a form of sympathy for the defendant, which is also outside the box, outside what you're supposed to consider as a juror. So you have to deal with that in voir dire to get jurors who could still do that, could put a value on it and be an appraiser without considering who is going to pay, right? Whether it's the lady or insurance, because you can't mention insurance in trial. So that's like a false type of sympathy for the defense. And that's, you want to avoid that, because that would be dismissing the case or losing the case for an unfair reason, right? Because that's not an actual reason. Ace asks, in response to my video, insurance tips for maximum payouts, he says, my case has dragged out so long and I have had multiple lawyers working on the case, multiple firms. My recent lawyer who's taken over doesn't seem like he's doing much to help me improve my case. I haven't been sent to a new doctor and it's been over a year almost since he's gotten the case. What are my options now? It feels as if there's a time limit for these cases and it's not my fault. My second lawyer, and then he continues, and I guess it gets cut off. So yeah, I'm sorry to hear that. The best thing to do would just be to text me also, because that's more of a specific, real factual question that you're having with your case. So what I could do is, if you give me your name, I could look up the case. If it's in the New York case, for example, I could look it up in the court's public filings. I could see what's happening. I can give you some insights about your lawyer, about the case, whatever you have questions about. Just text me 347-566-9595. But yeah, getting too many lawyers sometimes is not good. If you have one lawyer, you're really not happy with them, you could switch one time, but you don't want to start going to multiple lawyers. Then everything becomes confusing and there's a soup of, it's like 20 people making a soup. It's gets so confusing. Nobody knows who did what. And then it just leads to problems. Bill asks, should a plaintiff in a civil suit continue to submit proposals for settlement to the defendant after the defendant has already rejected multiple proposals for settlement, like rejecting $1 million proposal for settlement and then rejecting $750,000? Yeah, so I wouldn't do that. I don't see what's the point of that, because you're going down and they're just quiet and not giving you anything, right? if you ask for $1 million, if they think $1 million is too much, have them give you something like 150. Then you could say, okay, you're giving me 150. Well, I'll come off the $1 million. I'll come to 950. But you have to give me something in the whatever you want, right? In the 3s and the 4s and the 5s. But don't just keep bidding against yourself. Basically, they're not telling you anything. They're just saying no. And you're like, $1 million, no. 750, no. 500, no. 300, no. What's the point of that? You're just bidding against yourself. And see, the way I negotiate is completely different. Like I talk about my settlement opportunities. I do it the opposite way. I tell them, hey, pay me $1 million. You have 30 days. If you don't, that's fine, but it's never going to be $1 million again. This chance to settle for $1 million is going to disappear like a train that left the station. And now when I go to court, it's going to be 2.5 million, right? Or it might be more than that. It might be 3 million. And I just keep going up the staircase rather than down. And that's much more effective because then you're creating fear in their minds, right? They're like, oh no, what's this guy doing? And he's preparing it for trial. And he's looking at these big numbers. And then they're going to come up to where you are, as opposed to them dragging you down into the depths of, despair and pennies. You don't want them to drag you down, so don't do that. Sach Sunil says, in one case, my attorney said the case will never settle as the defendant is not willing to settle the case and pay a judgment. What could be done? Yeah, so if they don't want to settle, just prep it for a jury trial and try the case and just get a jury verdict. They don't have to settle. A settlement is an agreement, right? If they like the case, if they think they have exposure, they can offer you a settlement, but there's no law that says they have to settle. They could just say no, and then you have to go to trial. So it just depends on the case, the underlying case. If the case is strong, you win. If the case is really weak and bad, then you may lose. But you have to ask why they don't want to settle. You have to understand the reason why. That's the central issue. And Tekevin asks, hi Arkady, how often do you see defense attorneys asking for different evidence outside of medical, like emails, phone calls, text logs? Does it matter if liability was already established? Yeah, I think that depends on the type of case. Photos are usually requested. Like you see photos a lot. You might see video surveillance a lot. Now, emails and texts maybe, for example, if the plaintiff says he emailed to complain about an unsafe condition before the accident or the injury even happened, they'll say, well, show me the email, show me the text message that you sent, right? If I say I sent a text about a crack in my ceiling a month ago, and then my ceiling completely collapsed on my head, they're going to say, well, send me the email, show me proof of that, right? But phone call logs, that's more rare. I don't really see that too often. And if liability is established, there would be no relevance of, let's say, phone calls, right? Or even these text logs like I'm talking about with the ceiling, for example, that only goes to liability. For damages, it would be probably less. Damages would be more like photo albums or medical records, things like that. So yeah, it's usually what I see. @2preach says, I don't know if it's my lawyer tactic or my case is being handled slowly, but there's 57 days left to be able to file a lawsuit. And just now they are sending a demand packet, but both ladies did take maternity leave at different times the last 4 months. Yeah, so it's not good to wait until the last minute to file, because what happens is if you wait until the last minute, you're suing whoever you know could be a defendant. But then what if they say, oh, it's not us, it's this other company we had a contract with, but now you're beyond the statute, so you can't sue the other company, you see? So it's good to file the lawsuit as early as possible. And the demand letter, the only reason you have to delay the demand letter is if you're still getting medical care, because then you're not done. So if I send your partial medical records, I'll get a partial settlement, right? But then you want to get the full settlement for all your injuries. But if you're done treating, you have 3 years usually in most places. Some places you have 4 years, some places it's 2. But if you're done with your medical care, what would be the reason to wait? You just send the package, see what they're offering. And the only cases I really settle pre-lit are usually the small cases, like 10, 20,000. Bigger cases should be in court, and then you could settle them also, but you settle them while they're in court, while they're being pushed towards a jury trial. And then Terry asks, I was in a car accident and I am suing multiple defendants. Does my lawyer get 33% of the whole or 33% of each? I'm in Pennsylvania. My lawyer doesn't really communicate very well. Going to mediation in March of this year, 2025. Yeah, so usually it's 33% of the entire settlement. So usually the case is resolved at one time, so you have multiple defendants, but it's resolved at one time. So you might say it's resolved for $1 million. He pays 300 and this one pays 700, but it's resolved for $1 million. But it would be the same, right? Whether you took a third of 300 and then a separate third of 700, or if you took a third of the whole million, it's the same thing. So yeah, it's usually how it works. Sometimes cases do settle like partially, like if one defendant, especially if one defendant is like really not at fault, you don't want to keep them in the case because they're going to keep asking you discovery documents and depositions, and you don't want to have like 20 lawyers to fight with, right? And you see they're really not in the case. So they might say, look, we're not in the case. We didn't do anything, but you know what, just as good faith, we'll give you something, 10,000, like nuisance value, 5,000, 20,000, whatever it is, right? You take that money, you take a third of that, you pay the client, and then the case continues against the real targets. That happens sometimes. Reginald Williams says, in response to my video, insurance tips for maximum payouts, he says, in my case, they hired a delay sleep firm. So annoying. And I guess he means the defense firm is more like a firm that delays and sleeps on the case. Yeah, that is, annoying, but it's better to have a firm that's like what you call a sleep firm compared to one that keeps peppering you with nonsense letters, motions, or hearings, or, that's even worse because then you're always like doing something and you're not getting anything for responding to their bogus, discovery demands that are irrelevant, but you're just doing work, but you have to do it, right? Because you don't want to get the case dismissed. So I take a sleep firm over a peppering firm. And then Vic Trees asks, what if the second lawyer turns out to be worse than the first? What if the client wants a trial and the second lawyer wants them to take a settlement? And what if the client, sick of this BS system, says, I'm going to die with this debt, then make you 40% of my bodily injury, pain, and suffering? Since the lawyers signed agreements, they would be paid out of the settlement that never happened. Well, no. The condition, the way it works is contingency, right? So they have to win the settlement for you. If they get you a settlement that you're happy with, that you sign, then they take 30 or 40% of that. But if they don't get it for you, then they didn't, it's like a contract. They haven't gotten you anything. See, their fee is contingent or, based on them winning. If they haven't won a settlement, if they haven't won a jury verdict for you, if they don't have any money for you, then they don't get anything. So yeah, it's based on that. So you don't have to worry about that. But yeah, it's unfortunate. Maybe, you go, I don't know, you speak to them, see if they can improve, or if not, it's just important to have the right lawyer because then you're in a power position and you can go to trial and win the case. But if you have a bad lawyer, then everything kind of, like a house of cards, it all breaks down. And then Octavio says, good morning. Your videos are very informative and I love them. I have a question. What does it mean when the court says that your case is collecting interest from the day it was filed? Someone mentioned to me that lawsuits gain interest until the end of it. Thank you and have a wonderful day. Yeah, so usually the way that they do get interest is if you have summary judgment. And if you have summary judgment on liability, then you get 9% interest against a private defendant from the date of the judgment up until the trial. Now, some states might also have interest for other reasons. Like, for example, if you did an offer to settle for a certain amount and then they don't want to settle for that amount, then you could say, well, now I get interest if I beat that number, right? If I say, hey, let's settle this for $1 million, and they say, no, we don't want to pay that, then you say, okay, but if I go to trial and I get a bigger number, like 10 million, well, you're gonna have to pay interest. I think they have that in California. It's known as a 998. So they have, different rules in different states on that. And then here's a question. What happens with the client lives out of time in another state? The stonewalling could cost lots of time and money lost for time off work for the client. Could there be any fines dealt toward the defense? So usually not, unfortunately, but what you could do is you could tell the judge, hey, my client doesn't live here. He lives out of state, so he has to come all the way here. So let's get a date for the deposition, and it has to be a date certain. They can't adjourn it last minute because he's going to have to, arrange airfare or train tickets or whatever it is. So you just have to file motions, and eventually, if they keep delaying, the judge will sanction the defendants by precluding them from offering any evidence, or the judge could also strike their answer, and then you win automatically. And then Terry asks, what doctor do I see about a TBI? I had a car accident 4 years ago and had a concussion with loss of consciousness. I have an attorney. I have PTSD, but mentally I'm struggling. I don't believe I'm okay. I have so many problems that would associate with a TBI, but I haven't been seen by a doctor that would look for that specifically. Yeah, so usually a neurologist, or it could also be like a different type of doctor, like a PM&R doctor. And then what they do is they quarterback your care. So what I've seen with the traumatic brain injury is it's good to have a neurologist. It's sometimes good to have also a neuroradiologist that will do like a 3T MRI or a DTI, which is a diffusion tensor imaging. Those give you the films, right, and tell you what's inside the brain. Sometimes the films don't show it because it's very microscopic, but sometimes the films do show some kind of TBI. And then you also have the neurologist who's treating you. And then the third one that you may want to get, not always, but sometimes, might be a neuropsychologist that does certain tests, like counting backwards by sevens and all these different tests to see how you're doing, right, and kind of assess you and evaluate you. That's a neuropsychologist. And then usually if you have all three of those, you have enough to show a TBI. Ricey says, you should always hire experts in the beginning. I had to myself, even before obtaining a lawyer. And this is in response to my video, early expert hiring boosts legal success. Yeah, absolutely. You definitely should hire experts as early as possible, because some of these cases are very technical, whether it's like a trip and fall, but they have to do with the building codes, or engineering, or truck accident, but they have to do with all these different trucking standards, the Federal Motor Carrier Safety Regulations, or truck manuals. So if you hire an expert, they're going to tell you, hey, this is what the case is about. They're going to really, hone in and zoom in on the issue. And then you just kind of like ask the questions about that issue, get all the discovery, the documents, get the proper witnesses. Whereas if you try to do it yourself, you don't have an expert, you might be asking away questions, hundreds of pages of transcript, but it's about the wrong issue. It's not really, you never really hone in, and then you could lose the case. RG says, is the defense attorney obligated to inform the insurance company and the adjuster assigned about the settlement opportunity letter? Sometimes the defense is very stubborn and think they can win in trial. Yeah, I mean, they are, but I don't send the settlement opportunity letter only to the defense lawyer. I send it primarily to the adjuster, on the case, and also to the lawyer. And I put right in the letter, this should go to all the money decision makers, all the decision makers who decide how much to settle the case for. And I said, send it to the adjuster, send it to the supervisor, all money decision makers. So I send it to the adjuster directly, and then I also CC the lawyer, of course, because they're the lawyer. And then I also tell them, send it to your client, to the policyholder, to let them know that, hey, I'm willing to settle within the limits, but you're exposing them, right? Because if you don't take my opportunity, then it expires. Well, let's say your policy is $1 million. I'm willing to settle within the $1 million for $1 million, $950, whatever. But once this expires, it's going to be $3 million, but all you have is $1. You don't have any more. So now if I get $3, who's going to pay the other $2? This poor policyholder, this insured, whether it's a business, whether it's an individual, they can get really, really financially hurt. And it's because of your choice not to be fair right now, right? So that's what I do. So that's much better than just sending it to the attorney. Because yeah, you're right. I mean, the attorney might not even show it to anyone, and that'll screw up everything. RG Society also asks, how long before mediation normally do they tell you and prepare you? So yeah, I mean, as early as possible. Usually whenever you schedule a mediation, if I was to schedule a mediation today, probably I would schedule it for April, right? Because now it's February. It takes a few weeks. Everyone's busy. Everyone has a busy docket. And then as soon as it's scheduled, I would tell the client. But you don't have to really prepare the client for mediation, because mediation is, remember, just a chance to settle. It's really the lawyers doing it. So the client could show up, or they could not even show up. There's nothing really that the client has to do to be prepared, for a mediation. And then RG Society also asks, is it normal your attorney tries to keep your expectations low? Maybe in case you go to trial, anything could happen? Yeah, I mean, that's true. Many attorneys, what they do is they try to keep your expectations low. And then, if they beat the expectations, then they look like a hero, right? So they say, oh, I don't think your case was worth very much. Maybe it's worth $50,000. And then if they get on the phone and they get you $75,000, they're like, look what I did. I'm a hero. I got you $75,000, where we talked about this case is only worth 50. So that's what they do. It's kind of like an old trick. But really, it's not the best thing for you. The best thing for you is to really build the case and get full justice. Because if there's $1 million policy, then what are they talking about? 50,000. If you have an injury, it's worth way, way more. So it just depends on, whether the attorney is a real trial attorney, whether they have a passion, whether they're willing to work hard and go to court and get the maximum. Here's a question from Steve. He says, hi, sir. I was in an accident in 2021. I have a lawyer. He told me he got all my documents. Now he says it's going to go to the high court. I was worried because I was asking myself, what could be the reason? Can you explain it to me? So, I mean, if he's just going to go to court, it probably means, it's a good case. It could be a good case, and they're not offering enough money as a settlement, so he's going to go to court. So that's usually the reason people go to court, because the pre-lit stage, if you try to settle a case pre-lit, it's more like a voluntary payment. You're not even in court. There's nothing you can make them do. It's just like they want to pay, they pay whatever they want, right? They don't want to pay, you have no recourse. You have no way to make them pay. So that's why you go to court. So if he's going to court, that's actually a good sign. So I would, but if you want to find out why he's doing something, you should just ask him, because he's the one doing it. So he should tell you. That's the whole point, like the other person, right? Communication between you and your lawyer, that's critical. Okay, everyone, thank you so much. Please like and subscribe to our channel. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families. All the best. Bye-bye.